order.
Mr. Bartlett?
Here.
Ms. Browneye?
Here.
Ms. Galba? Here. Dr. Lewis?
Here.
Mrs. Rankin?
Here.
Mr. York?
Here. All right. A little outline of what it is we're doing here tonight. We are holding a special meeting of council on October here the 24th to hear an appeal from MPF regarding an ARB decision regarding the Ferris House roof. We are conducting this meeting prior to a regular council meeting, so we are therefore up against a very hard stop. This meeting is going to stop prior to the start of the 6:30 meeting. The way I'm going to set this up is that MPF and their representatives will lead off, and they will have 15 minutes to present your case. The village will then have 15 minutes to make a rebuttal to the case. At that time, at the end of that time, there will be 10 minutes that we will take questions from any resident in the gallery. And I will extend that for as long as I think time allows, because I wish to allow for the remaining part of the meeting. We will close off from the gallery, and council only can ask questions, and at the end of which we will then take a vote. Is everybody clear? All right, and for a visual aid, we have a timer here. I think we do. That will help, you know, in your
I don't think
time.
it's gonna reach, but I can do that. There's no other strip? Oh,
Okay, that's,
if we get close, I can hold it up if it helps.
Can I have that one? Can I have that after?
Yeah.
Dave?
All right, you good with that timer? Miss Ryan, I believe? Yes, would you stand?
Good evening, Mayor, members of council. Thank you this evening. My name is Kathy Ryan from Wood and Lamping, and I'm here representing the Mariemont Preservation Foundation regarding their appeal on the Ferris House. I want to thank you for the reschedule from the last meeting. First off, I would like to object on the record to any sort of rebuttal by the village, as this is a quasi-judicial hearing and the council sitting essentially as a judge. I would anticipate that the appellant, Mariemont Preservation Foundation, would make our pitch, and then any opponents that presented at the ARB might be here to rehash any of their testimony, and then we would get a closing. So I would object on the record to anything varying from that.
All right, I will note your objection.
Thank you. So this evening, we're dealing with a very simple dispute regarding an interpretation of a zoning provision. We have no facts at dispute. We simply have the zoning code and how it's being interpreted in light of a simple request for the change of a roof material. I'll start off with kind of the simple kind of guideline that zoning regulations are construed in favor of the property owner, and their scope cannot be enlarged to include limitations not clearly set forth. And so that gives you kind of two scenarios, one where you have some very unambiguous language to which you are bound completely, and you have scenarios in zoning codes where you are bestowed a certain depth of discretion and maybe some standards with that discretion. Here, we are dealing with a very simple zoning regulation that applies in a manner that is unequivocally clear. There is a proposed roof materials change, like for like. And that is what the Mariemont Preservation Foundation is proposing. And I'm a visual person, and the way your code's written, I thought it would be easiest to kind of start here. We're essentially dealing with three kind of provisions. And I will note on Exhibit 3 that the staff report to the ARB stopped short by just providing us this first one down here. We're dealing with essentially 151.075H2I. Roof treatment shall be of the same type and form and the same or similar color and exterior materials as found on the existing building. It is our contention this is it. This is what applies to the Mariemont Preservation Foundation. However, it says or brought into conformity with division H2F above. And that's kind of why I'm starting at the bottom working up here. If you proceed through the code and you proceed to H2F above, this is applicable for buildings identified in division F1 through F12 above, which are parts of complexes involving several buildings. When you go up above to that section, in fact, you do have these 12 buildings that are part of a building complex. And then you have 13 through 24, including the Ferris House at number 18, that is not. So when you come down here and you cross out the part that doesn't apply to the Ferris House after the or, the applicable provision for the ARB to review is an unambiguous provision, objective standard. If someone is proposing a roof material and none of these apply, they are able to exchange like for like and no additional discretion is bestowed. It makes sense here when your legislative body adopted these provisions that I believe the Mariemont Preservation Foundation had a hand in. They said, okay, we'll do the like for like, but some situations that's gonna throw it off kilter. We've got complexes that have multiple buildings. That gets us a little bit too far away from our intent. But we'll allow that in a limited circumstance for these. And so in this scenario, we're simply dealing with that list. And there simply is no other discretion provided. And all the Mariemont Preservation Foundation is asking tonight is that the letter of the law of these historic regulations be followed to a T as requested, and as they've stated and is in the record. They have, a need to replace the roof. This isn't a historic building. It's got an urgent need to replace the roof. And that is simply what they're asking this evening. I have Doug Mansler and Paul Mace here from the foundation for questions. However, as I stated, this is simply an interpretive issue regarding one provision. So, but they're here if you have questions. And that is all I have. Thank you.
Got time left.
Should I move this now?
You can if you want.
Yeah,
Well,
probably.
we can't really see
another
it,
10
so
minutes.
if you can put it somewhere so that we, did you see it?
Could you
I can't see it at all.
Well, there may be
Yeah.
questions.
Yeah.
Just right, yeah. I just want to look at it.
Ready to reset.
Well, it's set at 10 minutes, so I didn't know.
It doesn't have to be on
Oh,
that thing.
gotta go.
Yeah, it's got, it's flipped the other way.
So they have 10 more minutes, based on what you said, about 15.
Yeah.
Thank you.
If they don't have any other speaker, then yeah, we can.
Good for looking at topics.
So we need to reset when I start.
Will you say something? Kathy, I would say this, excellent presentation, and frankly, that's what I expected you to say. I'm kind of treading on careful grounds here because I'm really the lawyer for the tribunal that's making the decision. But the only thing I'd point out, we're not dealing so much with Mariemont Code of Ordinances 151.075 HI. We're dealing with 151.075 H, all 16 components of that, in my opinion. And I think part of the parcel of that reason is one of the things I've talked with you about before, in that the whole mission statement for the Mariemont Preservation Foundation and the whole purpose of the Architectural Review Board that we have here is to maintain the integrity, both architecturally and aesthetically, of what was founded so many years ago by Mary Emery and John Nolan. So I think with the legislature here, they've got to look at everything, not just that one particular provision.
I'd like to hold just a quick
Sure.
closing after everybody.
Understand.
There'll be time for questions at the end of this, Some of my remarks are going to, I've sort of summarized, my remarks into a statement here, which I'm going to read because for the reason, for time, I think it'll be better to do it that way than try to recall it, off from memory. You ready?
Yep.
All right. It is my view that MPF is relying very, very strictly upon an interpretation of the Mariemont Code of Ordinances 151.075H2. Our code sets forth very specific instances of which will be considered in an appeal to the ARB. I think that MPF is missing the broader provisions contained in paragraph 151.075H2. And that is, there are 16 separate provisions within that heading code that are to be looked at in according, when the ARB is set to make a decision, and they run A through P. MPF seems to be relying on section, as she's shown in her bulletin there, on section H2I, and she basically just stated that the entire case is essentially based on the interpretation of that. However, if you look at section H2M and P, where it talks about the review that the ARB may use to conduct and give consideration that, as they set forth with those elements, A through P, but it clearly indicates that is not necessarily limited to all of those 16 elements. And I'll get to the other part of that. And as Rod Holloway has pointed out, that under Section M of that particular section of the code, historical integrity of landmark structure, including personal signage, shall be maintained according to the original architect's design, town plan, concepts, and philosophy of Mary M. Emery, John Nolan, and the Mariemont Company. Note that in Section P of that same code section, essentially the same language is set forth. What does all that mean? I think it means, contrary to what MPF is arguing, that the ARB does have a certain level of discretion that we can apply when rendering a decision as to whether or not a certificate of appropriateness is proper. The ARB did not deny this particular certificate of appropriateness based on any inappropriate reasons. And essentially, I mean, I've heard that that somehow our personal preferences are at play here. I can assure you they are not. We made this decision there was no malice involved, there was no capriciousness involved. It was not an arbitrary decision the ARB made. We essentially believed that we were following our code when we rendered that decision. I'm going to yield the rest of my time to Peter Wren, who is the chair of the ARB.
So when we do, are you pausing this or am I gonna? We just keep.
Well, this is part of the 15 minutes, right?
I don't think
No,
we're
he
going to
has the
run
rest
into
of my
trouble.
time.
Right.
Yeah.
Okay, sorry.
That's some.
So when we review anything, our primary goal is to figure out whether it's appropriate or not. So the questions we ask ourselves are, why is this appropriate? And then how does this preserve, protect, or enhance the architectural character of the community as a whole? Sometimes we look locally to a single building or a block or a group, but usually it's for the community as a whole. So that's the only sort of barometer or measuring stick that we use. So when we ask, why would somebody do this versus this, we're considering how does that affect future decisions? How does it affect any other thing that we would potentially have coming before us, I guess, which is a future decision, and our ability to render whether we find that appropriate or not. So, I mean, it's not very complicated, so I don't know if I need that much time, but our focus is the community's architectural character and not any one specific building or material or whatnot. And it isn't necessarily accurate to say that the board would have said no to material X, Y, or Z. In the process of asking about why would this be more appropriate than that or whatever, we didn't get very far in the meeting, and it was basically, this is what we want to do, and just render a decision on that. And so nobody on the board found it to be appropriate for the building, and so that was how we got to our decision.
And we were only, to the best of all of our recollections of everyone that was there, we were only presented with one option to consider,
Yeah, the asphalt shingle.
the asphalt shingle. So we were not able to make a determination based on, going through a couple of options. There was only one option.
There were a couple of people I don't remember
In the
exactly.
gallery
The
that
gallery that had other materials, but they weren't presented as things to be considered. They
Yes.
were others, but the dialogue didn't get very far past, this is the one we want to do, so.
No.
I don't know what else to say.
Yeah, do you want to add?
No, I think this went a little bit faster than everyone thought it would go, but I think you said you're going to open it up.
Yeah, we're gonna open it up to
gallery,
questions
so if
from the
anyone in
gallery now.
wants to ask questions,
Yeah.
they certainly can.
Sure. Do we have anyone that, Bob, stop. Go first.
State your name.
State your name.
There's a court.
I'm Bob Van Stone. I live at 4050 Lytle Woods Place. I am a trustee of the Mariemont Preservation Foundation. I am embarrassed and frustrated by the actions of the officers of the foundation concerning the replacement of the Ferris roof, the most historic building in Mariemont. I am not sure the officers have standing to represent the foundation. Mr. Mace, president of MPF, misrepresented the facts to the trustee when he claimed they presented multiple options to the ARB, which is not true. A vote was never taken by the full board to appeal the ARB ruling. At the last meeting on September 22nd, it was clear to me that a significant number of trustees, including the last two Mariemont Citizens of the Year, disapproved of the appeal. At the end of the meeting, as Mary Beth York was bringing up preservation and restoration, Mr. Mace adjourned the meeting mid-sentence. I would strongly encourage the MPF officers to withdraw their appeal immediately and make sure they have the support of the overwhelming majority of the trustees before going forward with the appeal. Matt Ayer's recent article in the Town Crier about the roof replacement at the chapel provides MPF with a great example of how to interact with the ARB. That article described how the Thomas Emery Foundation worked with the ARB, presented multiple options at significantly different price points. If MPF officers do not withdraw the appeal, I would encourage council to support the ARB and reject the appeal.
Anyone else?
Bill, do you want these on time limit also?
Well, yeah, I mean, they get 3 minutes.
3 minutes, okay, the normal 3 minutes, got it.
Anyone else? No one else wants to get up? Say anything? Dave?
I'm Dave Middleton down at 24 Spring Hill, which isn't a very historic site, by the way. So I like to consider myself as probably representative of the average person in Mariemont. I'm not architecturally skilled. I'm not here to represent either party. But I will tell you this, I am absolutely fascinated by the Ferris Building. That is a gem that is something I think long-term we just have an unbelievable opportunity with. And when I look at what the preservation is doing with it, making a museum, I also think is fantastic. What I don't understand is with all the investment that's been put in that building over the last 220 years, I don't know what the options are as a representative. But I would think going around, and I did this today, I looked at just driving around the village, and I saw probably one of every 4 buildings that had changed their shingles that, in my opinion, and again, this is just opinion, not fact, looked architecturally more suitable to what I thought the vision of Mary Emery was than some of the buildings that have not had their shingles changed, which is a traditional shingle. I don't know what you're proposing for shingles, but I just think architecturally this is a absolutely fantastic opportunity to make half of the building, which looks very historic, as historic as the other piece. That's basically it.
Thanks, Dave. You got another 3 minutes? Yeah.
In closing, I would note that while we understand there is a broader goal and policy behind preservation, historic preservation, there is a fatal kind of flaw in the rationale provided by the village. And that is the case that in the rules of statutory interpretation regarding zoning say that where there is a more general provision that could apply conceivably and a more specific provision, and they conflict, the more specific provision prevails. And so here where you have a list of things that are potentially applicable, and maybe a couple could be interpreted as loosely providing some discretion on something within the series in that list, that may apply. But in this particular case where it states that with roof treatment shall be, that's the key, shall be of the same type and form and the same or similar color and exterior material as found on the existing building. That gives you such a specific pointed reference to the issue of roof replacement that it doesn't provide the board with any further discretion, even with the sense of the broader kind of aspirational language or other things provided. And the last thing I would say about that is that if you disagree with the way that implements your policy, I completely understand. But it's simply not written in a way that is defensible under the rules of statutory interpretation under the Ohio law. And you're free to go through the legislative process and amend that to incorporate that discretion moving forward into applications if you believe that there needs to be more as you had described. And that's all I have. Thank you.
I want to respond to, well, go ahead, Peter.
But
I would ask as appellant that we have the final word no matter
Oh,
what
absolutely.
as our rebuttal.
That's
Thank
fair.
you.
That's fair.
So there's a, I don't remember which one it is, but there's one of the portions of that that talks about the original vision of the architect, or the vision of the
Yes.
original architect. And so I know that in discussions with other ARBs, like as an architect talking to other historical preservation societies or other, there will sometimes be 2 points in the code that disagree. And usually that goes into some sort of discussion about which one takes precedence. I'm not a lawyer. I don't know what all the stuff is with Ohio's laws, but in those conversations, we usually debate back and forth about what's more appropriate, right? So that it gets into a sort of a gray area. And on this one, part of it was to talk about how does it hold true to the original vision? And we didn't get very far with that, but that would be the thing that I would say would disagree with the roof must or should always be whatever was there before, you just put it on again, because that isn't necessarily in keeping with the original vision of the architect. So that's all I would say.
Yeah, and part of the problem, with that strict interpretation is because, we don't know in the past, how any given roof got on a building. And an entirely inappropriate roof could be on a building. And if it's down in the historic district, the guy comes in and, he says, look, I got license plates up there for a roof, and I want to put new plates up there. And we are then supposed to give him a building permit to do what is entirely inappropriate? And because our hands are tied, that the ARB has no discretion to basically say, wait a minute, we have to evaluate this a little bit, because we do have other elements within the code that would allow us to do that. So without that discretion, I'm not really sure what the ARB is doing. What are we here for? Yeah, sure, you can answer.
Thank you, Mayor. I believe there are some instances, intended or not, where things are referred to an administrative body, even though they provide virtually no or no discretion, and this may certainly be one of those. To your point about whether certain roofs are, when were they put on, or did they predate the code, that is a factual dispute that would be settled by the ARB. If someone were to believe that the applicant brought forth a roof material and said, look, I have this roof, and I want to exchange like for like, it would be up to someone, whether it's staff or somebody disputing that, to say, look, applicant, we believe that you put that roof on after this, the effective date of this provision, and so we don't think that you're afforded the benefit of H2I. And it is on the burden of the applicant to prove that they're entitled to replace non-conforming roof like for like. In this particular instance, there was no factual dispute. Everyone was in agreement. There's nothing in the record. There was no pushback to dispute that. But I certainly believe that the village has every right in instances where they suspect that that may be the case to bring that up during the evidentiary hearing before the ARB. In this case, that's not at issue. Everyone is in agreement, and therefore we would ask that this specific provision, with admittedly no discretion, be honored, and the letter of the law under the Historic Preservation Code be complied with strictly, and that the finding of the ARB be overturned. Thank you.
All right, counsel, any questions?
Ed, can you speak to what is
Did somebody go?
the
Oh, I'm sorry, do we have another,
I'm
did you wish to speak? Yes. Please.
Mayor, I would object. I've done closing arguments twice.
For point of procedure, I think that Kathy's made her point. I don't know what your point is, sir, but I think council can ask questions, and hopefully they'll answer your question when they do. Ask the one that you want to get to, okay?
I'd like to address that.
All right, it's up to the
I
mayor.
don't want to restrict a resident from basically giving his
All right,
opinion.
all right.
Procedurally, yes. Yeah, I will note, I note the objection. I note the objection. Please.
My name is Scott Degerberg, and I'm a resident of 3855 Oak Street, which is property in the Old Village on the corner of Oak and Elm. We've been residents of Mariemont for 30 years and 10-year residents of the Old Village. I am a member of the MPF and have always supported the MPF. When we had to do a new roof, and with our house being one of the original 4 Tudors in Mariemont, and therefore subject to the Architectural Review Board, provisions, our approach was, hey, what are the other houses that are like ours? What is appropriate?
What happened in their case is not relevant to this application.
I hear you, and I've noted the objection. Now,
I
please,
have to object
yes,
every
I know.
time.
Please allow him to finish.
I'm sorry, I have to do that to preserve it on the record. I don't have a choice.
And so we, our approach was to look and to understand, what is current, what is in terms of the appropriateness and what is on other buildings and the like. And I guess my point in this is that I just have to state, because I've been concerned about this, I'm just disappointed that the MPF has to, go through this process and objecting and spending legal fees, from donations made by citizens, on this account. And I think that the approach should be what is really the right answer for the village and for the preservation of Mariemont architectural integrity. Thank you for letting me speak.
Thank you.
Want to do another closing?
All right, are we completely, and I apologize, I did not see him. He probably had his hand up, and I didn't acknowledge it. Anyone else? I don't want to miss anyone else. Anyone else in the gallery? Brad? Nope. Paul? No? Changing seats? All right. Please, I knew you had a question.
Yes. So, Ed, what is, in terms of our role here tonight, is our role to ensure, and this just makes me nervous because I am not an attorney, right, that our ordinances are upheld to the letter of the law, whatever that means? Or do we have a different higher calling in whatever particular decision is supposed to be?
Yeah, that's a good question. I would have to tell you, and I think Kathy and I have talked about this in the past when she quotes the proposition that under the law, the specific always overrides the general. That's very, very true. But as this quasi-judicial body, number one, when I look back through this first appeal I think we've ever had of an ARP decision in all the years I've been here, and I think we do need to change our ordinance relative not to the specifics necessarily of what's contained in the 150.075, but rather than who's going to make that determination as to whether or not the ARB made the correct decision. So with that said, we are the legislative body, and we're in an awkward position because we are here to decide if the statutes that we have created ourselves and that we've relied on for so many years are in fact legitimate. So it's perplexing to me, and I've been very candid with counsel for MPF about that. However, with all of that being said, while I agree with specific overrides general, I think our purpose here is to try to give, since you're not lawyers, to give intent to what the code is all about. And that's why at the very beginning of the conversation tonight, I pointed out the main provisions of the code itself, why the ARB is even here in the village. And again, I have to laugh about, if you look at MPF's mission statement itself, we're here to protect and preserve that memory of Mary Emery and John Nolan, unless, of course, that pertains to a property that we own. You know, so I think your overriding impact would be to give force and credit to the actual overall intent of the statute.
So you're saying those other sections that Bill referenced, that talked about the more general?
Yeah,
Is that
I
what
think
you're
they're
saying?
very applicable.
So,
Very, very applicable.
and I'm doing some mental gymnastics here, so bear with me. So, I'm not clear. Are you saying, though, that that MPF is in essence correct in the argument they're making, but not to the aspiration of the ordinance that was written? And because those are in conflict, we are tasked with essentially determining which approach is more legitimate?
I'm not sure exactly what you're
Okay.
asking, but what I'm saying is, I'm acknowledging that she makes a very, very good legal point.
Okay.
But I'm also saying that you, as a legislative body,
Right.
have the ability and the duty to take a look at the whole statute in and of itself and make your determination as to whether or not the decision, and usually when decisions such as this are not appropriate, is when they use the words in the law, we use the words a lot, arbitrary and capricious, you know? And I think everybody knows what that means. So in my mind, as long as you don't think the decision of the ARB was arbitrary and capricious, then you certainly can't uphold the decision that they've made. If you think it is arbitrary and capricious, then you can make whatever decision you all want to make.
And do we factor in, okay, because I don't have the ability to discern legally what is appropriate, but that doesn't matter here. What we're
Correct.
saying, okay, is what you're asking us to decide is whether or not we consider the decision by ARB arbitrary and capricious. That is the decision we're making here
I
tonight.
think that's a pretty fair summation, right?
Okay. Okay,
So, just.
Thank you.
If I may ask you, Peter, since you're the chair, right, of the ARB?
Yeah.
So, because you brought it up earlier, there were no other options that were discussed, but some people in the crowd had some? I'm just trying to make sure I understand that part, because it was just this or
Yeah,
nothing.
it was the single, I believe, I don't remember who made it, but it was a 3-tab or whatever asphalt shingle. Maybe it wasn't a 3-tab, maybe it was dimensional, but it was an asphalt shingle.
So did ARB ask about other options that might be available?
Yeah,
And there just was no other?
we didn't get very far.
It seemed to circle back onto the one, they brought a sample in, they showed it to us, they had it here. In fact, I think we still have it in the office. And the conversation seemed to circle back on that one particular shingle that they were bringing in. This
Well,
is
the
what-
motion was to
This-
reject the one. The motion that was to deny the appeal was based upon them
On the-
presenting
on the one,
That's how
yes.
it was worded.
Yes,
So there
correct.
was no others considered for the
Correct.
ARB,
Correct,
because the motion only said the one.
yes.
And I will add, you know, as an MPF trustee, I was recused myself from voting, and either way, I wouldn't be able to vote on this decision tonight. I was approached by Paul for some advice, you know, like, how should we approach this? And I did suggest, if I were you, this is what I would do, based on my meetings that I've gone to in the past, this is what typically happens. We ask that we bring in several different materials for comparison, just so we can understand the process and see that the best alternatives were looked at and considered.
Okay. And so when you guys made that, so you guys turned that one down, you thought there was a better material, or just, what was the characteristic about it that said, we don't think this is appropriate?
Well, clearly, I mean, I'm sure we stated clearly that we wish to look at other options,
Okay.
because the one that was being presented, we weren't happy with it. You know,
Yeah.
because it wasn't, we just didn't feel that, you know, that would be the best option for the roof. It would be appropriate, there had to be other options, we wanted to see them. Now, maybe there aren't other options, but no attempt was made to bring them in here. So,
I'm sorry, Dr. Lewis, I have to object on the record to testimony during the deliberation of someone who's recusing themselves from voting.
Okay,
Sorry.
that's fair.
sorry, that's good.
Well, you're not voting, you can talk.
I don't think.
Yeah, she's not voting.
No, he was talking about her.
Correct.
Oh,
She's
her.
recused herself.
Then that's testimony, which is, this is the deliberation phase, testimony is closed.
Well, I would probably have to go so far as to say, when we talk about possible resolutions, as you well know, the fact that a case could have or should have been settled is absolutely verboten to bring up in a court of law, And so we shouldn't be talking about the possible alternatives. The fact of the matter is, I guess they didn't have any alternatives. And I think that may have been one of the reasons why the ARB actually did reject the roof system that was proposed, because they at least wanted to see something else. I don't know that. I wasn't
Well,
there.
that's why I'm asking. I was asking the ARB members.
Yeah, we
just
wanted to get in,
understand what they-
we wanted to get into a discussion about why would this be the most appropriate choice? I know there's budgetary constraints, we all have limitations on our budget, so it's not our business really what somebody spends, it's not really, I don't feel like I can tell someone to spend money, that seems wrong to me, so and I've had clients that, look, they want to do the quote right thing, but they can only afford something else, but you go through a process and you interrogate it and you talk about it and why this, why that, and you go back and forth. And so I wish we weren't here, but there is a mechanism for a rejection, and that's a resubmittal, right? So I've submitted to a board before and they said, no, you can't do that, you have to do this, and here's why. And we didn't agree, so we had an argument about it, and we go back and forth with the staff, and then we represent. And so that's the normal mechanism, is the debate occurs with the applicant and the ARB, or whatever board it is.
Yeah.
So, I mean, that's usually how it goes. But we just, like I said, we didn't get very far. So we got through the one, and there was a conversation about how much it would cost, and we don't really know exactly what all those numbers are. But then we asked, was there more, and they just asked for us to vote at that
Understood.
point. So I don't have the minutes, but.
Yeah. And I think to what Peter is also saying, essentially, is that instead of doing all of this, if the suggestion was made, all you guys had to do was go give us some other options, and we would gladly look at them. No, we're in here doing this. I know, you're going to object.
Well, and they're legally not required to do that.
Objection to that point, in an administrative hearing where like for like is requested, if we do not appeal, the law requires that we are never allowed to ask for that again. Claim preclusion would prevail there, as you know, we cannot go back and ask for that, so just.
Yeah, I didn't hear exactly what you said, but I have a feeling I
Preserve our
agree with you. Right,
request.
right,
We had no choice but to appeal, unfortunately.
right. I understand
It's a
that.
very restrictive part of zoning law, but nonetheless.
What would,
I'm not really sure I follow that.
why would that
I'm
be?
confused.
That's
Can
your
I,
only
can I
option,
ask
was to
Ed
do
a
this.
question,
That was your
please?
only option.
Yes, claim preclusion, the law says that to prevent repetitive relitigation of issues, that applicants or litigants in the courtroom contest do not go back and re-request.
There certainly is case law relative to that, but I think MPF of all people should know, and does in fact know, that this is a very kind and gentle community. And if they would have sent him back to the drawing board, it would have been no harm, no foul, no lawsuit would have been filed, could have worked collaboratively to come up with something. I agree with a lot of your general propositions of the law.
And not, we just have to be responsible for the law and understand that those limitations are there, rather than, taking a gamble on.
I understand.
No, I don't understand this.
Yeah,
So
I don't
MPF
understand.
couldn't come with another option?
Conceivably, when you present something to the request that they presented, they can never present again. And as for other
No, I'm not, I'm
options-
talking about other options. I'm not talking
other
about,
options, no, there is no discretion within the way your code is written.
I'm not talking about the code. I'm talking about two
Procedurally.
groups that have worked together and forever. If you look at what the goal of the ARB is in their section, in conjunction with the Village Preservation Foundation, there are 5 things in what our ARB does, where they work with the Mariemont Preservation Foundation. You don't believe they could come back with another option?
No, with all due respect, sir, to the legislative body adopted provisions, and you are bound by those, the discretion, unless it is written into the code, cannot be bestowed on an administrative board. It simply cannot.
That would be
if it-
true, that would be true
And
if a decision had been
unfortunately,
made by the
Yeah, I'm
ARB.
confused.
There's nothing to preclude you, when it looks like it's going south at the hearing itself, to say, well, let us withdraw this application and come back with something else, you know? And I think that's all they were looking for. You know, like I say, I don't think they want to be onerous. And I talked at the beginning about I got to be careful about not taking sides, but the side I take is to try to get the right thing done that everybody can live with. And I just believe that somewhere, somehow out there, there's a resolution that everybody can live with. You know, whether or not you want to stick to the letter of the law and go to a court over it, that's your prerogative. We can certainly do that. But I don't think that really serves anybody any real good things at this stage of the game. But it's your call. You know?
Can I just ask a question of Ed? Because we just did this with the planning and zoning. And the, I know it's not, I know.
Don't talk about that.
I'm just, it's my fault. But the developer came in with multiple times saying, first it was going to be a condominium association, and then this next time they were asking to become a PUD. And I know this has nothing to do with this case. So I'm just asking because I'm trying to figure out if this is right or not. But each time the developer had a question, they would bring it before the zoning committee, and they would say, yes, this is good, but can you give us more information about parking, or more information about the trees, or more information? And they went back, looked at it, did it, and submitted it to the planning and zoning again, and we talked it through. So I'm not sure why, it seems to me in this instance that there was a whole steps just jumped right over when you got you didn't get the answer you wanted. And I'm not sure why you didn't present multiple. I mean, I've been in construction and design. I've never had anyone come to me and say, this is the only roof I want, this is one I have to have. You usually get multiple bids and multiple people telling you, like, this is what I'm thinking. What one will work? Which one won't work? Why won't it work? And I just seems like we just jumped a big step, and I'm just kind of wondering why, and I don't know if I'm allowed to ask this or not, but why didn't you want to work with them?
To answer that, what you're referring to is like a concept plan, site review.
That's what this
process.
is.
No, in this case, for the architectural review board, the certificate, you are beholden to the provisions in this.
But you're not, and again, the roof that's currently on the Ferris house is nowhere near what was the original roof. It was a wood shingle. And so they weren't asking you to put a wood shingle back on, but I'm just kind of wondering why you didn't want to just have other ideas. It just seems like you're spending money on a lawyer when you could have spent the money on the roof.
There's nothing wrong with that.
Well, I know, yeah.
That's a matter of.
But that's all, I mean, that's the thing, that's what I'm confused about. I'm not even sure I feel comfortable voting about this because I don't know the whole story.
Well, we're gonna bring this to a vote. Because we have to resolve this here tonight. We have about 15 minutes
Okay.
before the start
Okay.
of the next meeting, and I would like to take a break. Anyone else have any, I mean, council, anyone else? Randy?
I'm just disappointed we've got here. I don't know how we got here. You've got the Mariemont Preservation Foundation, which to receive and maintain funds to be used for the public benefit and to maintain and enhance the historic integrity of the village. That's your statement of purpose. Your primary program includes to develop guidelines for the historic district to be used by the Mariemont Architectural Review Board to assist owners of historic properties in order to maintain the integrity of our National Historic Landmark status.
Mayor, can we make sure that that is also in the record since you went from?
Sure.
Oh, sure, yeah.
So when I got on council, there was I need my glasses for this one. There was a committee project to work with MPS Task Force to take proactive steps to preserve the village architectural heritage. And what that was all about looking at our codes and ordinances to make sure that the language was correct, there wasn't duplication, there wasn't anything wrong with ours. So that was added on May 13th of 2019, 3 years ago. So that was on there, and it was to work with an MPS task force to really fix our codes. So this is a code that is weak, in my view, because I'm going to get to the point where I have to vote. And I took an oath on January 3rd to protect and defend the ordinances. And while I think this is totally wrong, what they're doing, I'm going to need your guidance on how I need to vote. Because if I took that oath, that's how I have to vote. No matter how wrong I think this is, I have to vote like that. So I would respectfully request that the MPF go back to the ARB and we figure this out and do away with the litigation and suspend your appeal. That's the right thing for this village.
Amen.
Well,
Can we do that right now?
if they want to.
We respect
withdraw
each
their
other, we
application,
care about
they
each
certainly
other.
do that.
I think we can do that.
It's their call, Randy, it's not ours, you know, so if they choose to do that, they certainly can. But I think at some point in time, we have to do an up and down vote as to whether or not we are going to affirm the decision of the ARB or reject the decision of the ARB. And that's the, you know, you'd like to, I mean, we'd all love to settle cases. I try a lot of cases, believe me, I do. And I've never walked into a trial, ever, and I've had thousands of them in my career. I've never walked into a trial where I didn't say to myself, why didn't I settle this darn thing, you know, as opposed to spending 5 or 6 days in court. But at this stage of the game, if they choose not to withdraw and then resubmit, they have the right to do that, okay? If they choose to withdraw and resubmit, they've got the right to do that too. So it's their call. If they don't want to do either one, it's up to council to fulfill your obligations and say whether or not you believe everything we've been talking about here, or whether or not you believe MPF is the appropriate argument, and then rule that way, one way or the other.
Well, but there's always a little bit of right and a little bit of wrong on both sides.
I agree.
So
I agree.
did the ARB behave appropriately? You know, maybe they did, maybe they didn't. You know, I don't know how we got here, but we're better than this. So
Well,
I will again ask that the appeal be withdrawn. We go back to it and we can come up with a solution.
again, that's their call. That's their call, you know. So, and I don't see any indication from them that they're interested in doing that, so.
I would like to address Leah's comment that we didn't do anything to work with the ARB.
No, I didn't say that. I said, I asked,
Or
I
your
was
question.
asking,
We
yeah.
absolutely did. You know, we presented one that we believe that this is the best.
Just say your name, please, for the record.
Sorry, my name is Paul Mays. I'm the current president of Mariemont Preservation. We do believe that this is the best thing for the Ferris House in terms of first preservation. And we worked with the ARB and we submitted a letter that we believe, and Karen Sullivan wrote for us on our behalf. If y'all don't know Karen Sullivan, she also is a former trustee, also a former Mariemont Citizen of the Year. She is an architect and she has won multiple preservations awards. We submitted that letter, not only in the ARB hearing. I worked with Mr. Rand, several conversations. It was actually his suggestion to consult an expert, which we did. And she noted that the National Park Service, which is the ultimate authority in preservation, has recognized this home 3 different times throughout its history with an asphalt roof as being appropriate. She also noted that this is the most appropriate roof structure of what we requested from a preservation standpoint. So we did do this. I also worked with Mr. Wren and talked to him about, hey, what can we do? And Mr. Wren on several occasions told me, you flat out told me, you didn't care what we did as long as it wasn't asphalt. So, like, we tried working with you, and clearly we weren't getting anywhere. So we did do our due diligence. Doug and I met both with you several times, and you weren't giving it off. So we looked at other options. We saw other options. We believe this was the most appropriate. And to be painted in this picture today that this is against what MPF is doing, it's incorrect. To be painted in a picture that we didn't work with the RB, I did not want to be here.
I know that.
But we worked and we were told basically, if you bring in asphalt, we're not going to approve it. And I've heard multiple opinions. I've heard everything from put a fake slate roof on this house to keep it a black. I have heard that. You may have not heard from the RB, but I've heard people say put a slate. I know there's lots of opinions. We're just here today. We want to move forward. We got a lot of work to do with this community. The Mariemont Preservation has put a lot of money into this Ferris House. We have a lot more money to put into it. And we're just here simply today to ask you to uphold the law. You can have a different opinion. I understand that. We've been round and round and around since May on this topic. So we didn't get here willingly, but this is where we are today. So we're just asking you to uphold the law so we can move forward preserving this house, making it a museum for the Mariemont, and we can get back to business. So thank you.
And I didn't want you to think that I was just asking a question. I don't want you, I know.
Well, it's fine. I understand. It seems that that was how it was painted by the members of the ARB today.
So Ed, again, you said earlier, I just want to clarify for myself, the specific over general, there's still, there is the specific, it's in the code book, but you're saying the other two sections that Bill cited that are more general.
They certainly are applicable, that's correct. And again, since I explained previously that I think the real flaw in our code is not so much how it's written, it's the fact that the appeal goes to the legislative authority as opposed to another administrative agency. And like I say, in all the years I've been here, that one we had a couple months ago was the only one, and that was fairly vanilla. But you guys, and I can't make the decision for you, Rob, that's the problem, I hope that I've explained to you, it's not arbitrary, it's not capricious what they've done, which is typically the standards that you look to in overturning a decision of an administrative board like this. But if you want to say that, hey, I think they should have looked to the specific more to the general, that's your call. I don't know how else to explain that better.
Okay.
So just to reiterate, you are asking, is arbitrary and capricious a legal term?
Not really. I mean, it's used a lot,
Okay.
Yeah.
So you are asking us to, in a general sense, make a decision about whether or not the ARB board ruling was done arbitrarily.
Yeah, if it was uninformed or haphazard, something like that would be arbitrary, without any.
Susan, I'd like to re-point out that when we came in, this whole section of the code that lists which 12 buildings are brought to conformity and which 12 are not, was not part of our ARB.
Say it
So I
again.
don't know why that was not there, but it was only this section listed by the building administrator. So I'd like to point out, when we made that decision, we made this section of the code out. I didn't even know it existed until we got to this point.
I'm not really sure of the relevance of that.
The
What is the relevance of
relevancy
that?
of like an ARB's making a decision, but they don't leave in the code of the first 12 buildings that bring to conformity and the 12 buildings that have to be a like-for-like structure. I think it very well should have been. in this.
Yours is a very unique structure, and that was the overriding consideration.
Again, it's listed here.
We know where it's listed, yes, we know where it's listed.
But would that not be an error? Wouldn't that make sense that if we were going to the ARB and you're listing this section of the code, that you would also list the full section?
Again, I don't see the relevance.
You don't see the relevancy in your law?
No.
You're sort of making it sound like we tried to trick somebody.
Yeah.
We was trying to trick
No,
anybody.
I'm not trying to trick you. I'm stating a
Like,
fact.
we asked multiple times,
We're
just,
gonna have to wrap this up and get to the vote. How do you want to phrase this motion?
Well, you're just going to
Show of hands or what?
just make an up and down vote as to whether or not to uphold the decision of the ARB or overturn the decision of the ARB. Recognizing that Marcy cannot vote, correct?
Can,
And can I, as a point of clarification, do we need a supermajority or just a majority?
I need 4 out of 6, 4 out of 5,
4 out of 5, okay.
75%, whatever that comes out to.
so I guess,
You're the mathematician.
I mean, I don't mean to be difficult. I just still have a couple questions and it is almost.
Better make it quick, yeah.
Okay, so can I ask clearly why, and again, I'm just trying to process all of these different terms and what we're trying to decide here. Why is the asphalt shingle inappropriate?
it's the most historic building we have. It's the building that was here before Mariemont was here. It was originally a wood shingle way back when it was built. It just doesn't feel appropriate that a cheap asphalt one be the one that goes on there. We're not saying it has to be wood. We're saying, what else is there besides that? What can you do that's more historically appropriate?
And why did the letter of support from a preservationist, how did you factor that into the decision?
I mean, it was the opinion of another architect. I'm an architect. I read it. I don't agree. So, I mean,
Okay.
I'm not saying that it's factually incorrect, that it's not on the National Register of Historic Places. I don't know what NPS's decision-making process is, but they didn't come in and say, hey, asphalt shingles was a good call. They said, this building is a national landmark. We're just affirming that it's a landmark. They're not commenting on the roof.
Oh, the asphalt shingle.
Yeah, it was, somebody replaced it at some point. You know.
Okay. So did anybody with historic preservation credibility state that an asphalt roof was okay?
Mrs. Sullivan has won awards both by the Cincinnati Preservation Society and the state of Ohio, State of Preservation Society. So she's not just an architect, she's been acknowledged and awarded awards for preservation societies.
But again, that would be one opinion.
That's an
She
opinion
said
of
that
one
was
other
the
person.
most appropriate.
So she stated that the shingle was most appropriate, the asphalt shingle was most
It
appropriate.
also should be pointed out, she's a former member of MPF, and she may have a biased opinion toward that organization. We don't know. I'm just saying she's one, and I know Karen, I love Karen.
Okay, now I have another question.
No, look, we've got to take a vote
Just cut it
here.
off. Just-
Let's cut it off. We've got to take a vote.
Leah says she doesn't feel comfortable.
I don't
voting.
feel comfortable voting yet.
Well,
Well, I'm sorry. I don't know
And
enough
also,
about it.
Karen also noted, you risk by putting an inappropriate roof on this house, which I know they think might be more appropriate, you actually risk the nature of this building. So if we go out, and we did, and we didn't put it in it as an option, it was $98,000 to put a wood shingle roof on the house. If we go out and we put a plastic wood roof, I believe, and so did Karen, we're actually risking more of the historic nature of this building, because we don't have, that roof is not something, we know now it has an asphalt roof.
How long has it had an asphalt roof?
Since the 1930s, we
That's
talked
in
about it
dispute.
at the meeting.
We're not sure about that.
That's a
That's a disputed
Look, we've got
thing.
to stop, enough with the argument here. We've had enough. We're going to take a vote. I'm sorry.
Well, it's challenging for me because I'm just trying to figure out, right, yeah, I was asked to determine if the vote was arbitrary and trying to understand what, like, that's also a general term. And then a little bit confused of whether we were supposed to vote, whether we agree or not relative to the legal argument, which I'm hearing that we should not. We should vote on whether or not the decision was arbitrary, which then leads me to want to understand what went into the decision. So that's the challenge that I'm experiencing tonight, is trying to unpack that decision to understand.
As the argument was being presented to us, they had counsel. So that MPF seemed more interested in whether or not we had the ability or had the right to make a decision on whether or not they can do what they want to do, rather than talk about what's appropriate for this building. So they had already had a conversation with an attorney before they came in to have the meeting, which is weird to me. I've never talked to an attorney about an ARB presentation I've made. I've gone through multiple times. You go into different jurisdictions.
We had not talked to Kathy Ryan prior to.
You guys talked, you told us in the hearing, somebody mentioned that you guys had conferred with counsel on what our legal boundaries were. It was just, it was bizarre, so.
Why is that bizarre to know our legal rights?
It's not
never
it's not
happened
that
before.
part, it's that in the normal process of it, we don't get it and get it
Administrative
this.
hearing,
Sorry,
this
it's
is
okay.
wildly
It's just
inappropriate.
wildly.
We have a right as applicants and as property owners
Sure.
to have our rights determined against the legislatively adopted language, period.
I don't disagree with you. I don't disagree with you at all
And
about
I
that.
agree with the mayor.
I think though, I
We would
think,
like the council
excuse me,
to consider this and vote.
excuse me. I think, however, that the legislative body appears to be somewhat confused as to what their duties and responsibilities are. So if they ask if somebody makes a motion to reconvene at a later date to further discuss this, maybe get legal opinions from me, they can certainly do that. And that might put you off another week or so, but at least you'll get a better informed decision from these people as to what they feel is appropriate. So if you want to do something like that.
Just,
If
okay,
some-
let's.
We've got,
do we wanna do
I
that?
personally have to separate my obligation to protect and uphold the ordinance of village against my personal opinions of how I feel about this decision. And I haven't reconciled that. I don't know if you guys all feel the same way.
Well, I don't fully understand, because I'm not a lawyer, I don't fully understand if this, if the case being made, the legal case being made, trumps the,
Thank you.
the process. So that's, and then I'm just not clear on that. So if it is that we are about to uphold the ordinance, then yes, we need legal opinion, because I am not a lawyer. If the question is, you know, are we just trying to send folks back to the table to figure out a new solution? Well, I mean, of course we want a solution that everybody hopefully could find,
Well,
be comfortable with. So,
With my suggestion, I don't think we're doing that.
yeah.
You know, I can't make a motion along the lines of what I said, but I think if you're, it seems like everyone's biggest concern is, I don't know what the law is. I need to understand the law better as far as how I should rule in this thing. So with that said, it's not inappropriate to say, I would like to make a motion to table this decision and reconvene a week from now, 10 days from now, so that we can get council opinion, think about this more, and then make a decision at that point in time.
I'd
If
like
that's
to
what
make a-
everybody wants to
Somebody
do.
please make the motion.
I would like to make the motion.
Make a motion. Do I have a second?
Second.
We have a second?
I second it.
We're tabling it.
Yes.
Mr.
Yes.
Bartlett.
Take a vote on it.
Yeah, Mr.
Yeah.
Bartlett. Ms. Brown Knight.
Aye.
Leah.
Aye.
Dr. Lewis.
I can't vote.
Can't vote.
Well, on the motion, she can vote on the motion. Well, never mind.
No,
Okay.
I'm
Mrs. Rankin.
abstaining.
Aye.
Aye. Mr. York. Aye. All right. We'll table it.
Now what we'll do is we'll set it, let me reconvene with the mayor, see when's a convenient time. I promise it won't be too far off, okay? Because I know you've got some time considerations here, so we'll try to get something done. I'll get an opinion letter to them and let them know what the legal aspects. It's sort of funny that the lawyer for the Common Pleas Court is actually sending an opinion letter as to how the judge should rule on his decision, and that's the flaw in our system. I get it.
We
So-
find that gallery.
Okay. I'm going to adjourn.
Okay.
Okay.
All right, thank you.
Thank you.